My guest on this podcast is Dez Taylor, a legal expert that's been helping landlords and also letting agents on penalties, convictions and enforcement for many, many years now. And we talk about how some of the changes that are happening in the legal system right now could massively impact landlords in a negative way. We talk about what you need to do to protect yourself, be aware of these things. So let's jump straight into the podcast.
People don't realise if you're doing serviced accommodation or short-term lets, you're running a business. You're required under the Regulatory Reform Fire Safety Order of 2005. It's not a new regulation. It's an old regulation. You are required to have a fire risk assessment. The law says you don't have to self-incriminate. As the Americans say, I'm going to take the fifth, however they say it. You don't want to incriminate yourself, but at the same time, you don't want to mislead.
Yes.
But if you've been caught doing something and you want to stop it. If you are driving along the high street at 29 miles an hour and somebody falls on the road in front of you and you hurt them and kill them, the police will defend your position that you didn't do it on purpose. Even if you're driving at 30, they will defend your position. But at 31 miles an hour, you have committed manslaughter and killed that person through your breaking the law.
Hey Des, you're the person that's helped probably about 2,500 landlords and letting agents with compliance challenges with the local authority. Why is it that tenants and landlords have these problems in the first place?
The real reason I think people have the problems is because they don't understand that all the requirements that are there to be a landlord or to let a property, and the council knows what those are because the legislation has been around for more than 20 years. And when they get caught in something, they tend to fight back rather than listen to what's being said about what they're being alleged to have done, see how it can be resolved and seeking professional advice. And most sources of problems with a tenant start because we didn't do something quickly enough or fast enough when they make the initial complaint, and then that escalates to the council. And the other reason is because of artificial intelligence or machine learning, which has been now being used for about 8 years or so by local authorities, they have much more intelligence about where offences are more likely to be committed, such as not licensing a property. So you're going to find technology and human behaviour and, of course, I don't think propaganda is the right word, but the marketing of landlords are not so good by sub-organisations.
Yes.
Means that tenants go and seek advice on minor things which turn into bigger things.
Yeah, and often that will get triggered because a tenant's unhappy about, for example, landlord's not getting the boiler fixed. It doesn't think it's such a big issue and leaves it dragging on for weeks and weeks when they need to get it dealt with straight away. And then that starts a spiral of problems.
Yeah. So as soon as there's any issue with heating, it's an implied obligation under the Landlord and Tenant Act in 1985 that you will provide space heating. And you need to make sure you provide space heating and for water heating. And if you don't have those things and the boiler breaks down, then you need to provide alternatives. Now, I'm not an advocate of portable heaters, but if the boiler goes down, go and get a bunch of portable heaters delivered. There are organisations that same day deliver, and those things can be as cheap as £20.
Yes.
That solves the problem temporarily. We move them afterwards. And if there is no hot water, well, go and get a big urn so they can boil some water up, at least maybe to make tea, to do some washing, etc. And in my own experience with HMOs, when a boiler would go down and we couldn't get it fixed, or we need to replace the boiler, which you can't generally do in the same day, we would organise with the local hotel to book a room that they could go and use and go and have a shower and clean themselves and change. Does it cost a lot of money? It's a lot cheaper than enforcement action.
It's been proactive and making an effort.
Absolutely.
So enforcement often results in quite sizable fines. We're not talking a few £100s.
No.
We're talking thousands and many cases tens of thousands of pounds. So how are these fines kind of established in terms of how big or how small they might be? How are they determined?
Okay, so we need to go back a little bit in history. And if you had a situation where you didn't have a license, say in 2015, the local authority would take some enforcement action against you. Now, their options are generally to fine you, but they couldn't fine you in those days without taking you to the magistrate's court. so you had to be prosecuted. But they were able to recover their costs of any enforcement. So if you didn't have a license and they had to send you out some notices and maybe tell you that you need to get a license and tell you to get that application in, and they had to do a visit, they might have a cost of maybe £300 or £400. So they would be able to recover that by imposing a recovery, I'd say £300 or £400 on you.
Yes.
And I have paid one of those fines. So I'm happy to admit I paid one of those fines back in 2015. What happened in 2016 was the Housing and Planning Act 2016 was passed, and in 2017 it came into force, and that gave the local authority two things it could do. One, it could impose financial penalties without the need for prosecution. They just needed to have the same level of evidence at a criminal level, so beyond reasonable doubt, and they had to be able to produce that if it was appealed. The second thing was the introduction of rent repayment orders. Before, unless a landlord was prosecuted, a local housing authority or a tenant was unable to apply for a rent repayment order. Now the prosecution doesn't have to happen. So that has seen more and more fines coming out. It's seen more and more rent repayment orders happening. From a council point of view, in order to comply with the regulations, what they needed to do was set an enforcement policy. So they set their enforcement policy, and that would have a scale of fines, could be from 0 to 500, 500 to 1,000, up to £30,000. And how they write that policy and how they impose those fines has to be written and has to be published. Right. Once they've done that, they apply that in how they decide to fine you. And of course, there have been many cases since 2017 that have gone through the tribunal, have been appealed, have been taken to the upper tribunal. Some have gone to the High Court as well. And the key thing is, even on appeal, the judges and the panel cannot really go away from what is the policy if it's been followed by the council. So for a portfolio landlord, somebody who's got generally more than 5 properties, and if they've got 20, even more so or more, a portfolio landlord is going to be at the higher level of fine than somebody who's a hobby landlord with 1 or 2 properties. So what we see generally for not having a license when you should do a selective license. So here in Birmingham, where we are today, you need a selective license, and you additional licensing for HMOs and mandatory HMO licenses. The fines are probably going to be between 6,000 and 8,000 for a hobby landlord. For a portfolio landlord, they're likely to be 20 to 25,000. Yeah. They certainly would be in London.
They're quite significant amounts for mistakes that can be made. And if somebody's in that situation where they've been served some kind of notice or a problem has arisen, what's the best approach for them to deal with that? Because we were talking beforehand about often people think, well, I'll kind of fill in forms, send out the information and stuff. Sometimes that can lead to potential problems as well.
Yeah. So the moment there's any investigation by the council, they're normally going to ask you to fill in a form. Sometimes they're going to ask you to fill in something called a Section 235 form. That comes under the Housing Act. And that's going to ask you details about the premises, the occupation, the people who occupy the premises. It may ask you for certificates, tenancy agreements, etc. People are often asked to sign the form and confirm what they're sending. There's no need to sign that form. There's no need to actually fill it in. You could provide the information without doing so. But I wouldn't do that without taking professional advice, because you are entitled to not incriminate yourself. Yes. But also at the same time, you should help with the inquiry, because not helping with the inquiry is probably going to go against you, but seek advice to do that. The other form that quite often gets sent out is a Section 16 inquiry. Now, that's not under the Housing Act. That's under the Local Government and Miscellaneous Provisions Act of 1976. And that generally is to find out who has an interest in the property or the land. So they'll ask about freeholders, leaseholders, who's the mortgagee, who is the mortgager. That mortgager, by the way, is the person who takes out the mortgage. The mortgagee is the mortgage company. Many people get that the wrong way around.
The borrower.
Yeah. So very, very important to get those right. And they'll ask other questions, maybe about the insurance, but they are entitled to do that the same way as if they were going to do a compulsory purchase order. They would do the same. And they get that information so they can gather who all the people they may need to take enforcement action against. It's unlikely they're going to take one against the mortgage company, but they get that information anyway. Any offences or any notices that are served upon you will be served on your mortgage company as well. Many people don't realise that. So it's quite important. And the other thing that happens is they might ask you to come in and have a chat. And in the letter that you receive, it'll always
use that language though.
No, it's probably going to say, would you like to come in for an interview under caution? Or would you like to come in and have a chat about this? I must warn you that I'm cautioning you. And, you know, on the TV, you've seen the TV cop dramas. You don't need to say anything, but if you do anything, you say, etc., etc. It's the same wording.
You've heard the phrase, your network is your net worth, and you'll also hear it in this particular podcast as well. That's because people in property recognize the importance of being connected with other people. Property is a people business, and that's the reason I've been running a networking event for over a decade now. Each and every month we bring like-minded people together, an opportunity for you to come along and meet some of those people and also learn from other people on the stage, learn from myself as well. So make sure you book onto the next meeting. We're on the third Tuesday of every month in Birmingham. Now let's get back to the podcast.
In America, they call that the Miranda rights, by the way. But it's your right to silence in England. And that right to silence in history is over 2,000 years old. But in law, it's only been 300 or 400 years in the UK that's been a defence. Right. You don't have to say anything. But if you don't, it's also taken against you as well. So staying silent is not clever, and not doing anything is not clever either. Seek professional advice to know what to do. If you do go to that interview, I'd be surprised if you would come out saying, I'm really glad and I feel really comfortable and my conscience is really clear that I've done nothing wrong. You would be the first one, Saj, to say that, because everybody who's ever come out of one that they went to that we didn't advise them or they went before we were involved, they've always come out and said, why did I feel like a criminal? Why was that hell? I felt like I was like one of those criminals on the TV. I was waiting for them to bash my head on the table type thing. That's how they feel, and nobody wants to feel that way. And essentially, they're just following a process. Is it right? Is it wrong? That remains to be seen. But our advice is don't ever attend one of those interviews without professional advice beforehand.
We touched on rent repayment orders earlier.
Yeah.
How do they come about, and how is the amount established, and who is ultimately responsible for paying those as well?
Right. So rent repayment orders is nothing new. It was in the Housing Act 2004 at section 73.5. The difference changed under the Housing and Planning Act 2016 at section 40, where they said that you no longer needed to have a prosecution of the landlord in order to make the rent repayment order application. So you make an application to the tribunal, and there are a set number of offences for which you can get a rent repayment order. The most common is because the landlord didn't have a HMO licence or a selective licence, but it could be for an illegal eviction, which is harder to prove. It could be for not complying with an improvement notice, or not complying with a prohibition order, or not complying with the planning enforcement notice. Those are the main things, and the fines that you get for those are independent of the rent repayment order, so you can essentially be in double jeopardy.
So the local authority enforces and will impose the penalties, and the rent repayment order, would that be by the local authority or by the tenant that drives that?
That's an excellent question. Both can make an application, but it's who's paying the rent.
Right.
So if the local housing authority is paying the rent through housing benefit, they would make the application.
Okay.
And if the tenant is paying the rent, they would make the application. Now, if the tenant is also claiming universal credit, any element for rent of the universal credit is not reclaimed by the tenant. It should be reclaimed by the Universal Credit Department, but I've never seen that done. So the tenant makes the application. Whether they get 100%, there's a process that's followed by the tribunal. And there are many firms out there who represent tenants in this, and they work for a commission of the amount of money they get. So essentially conditional fee arrangement lawyers or representative firms. So they want to get as much as possible. But there is a set process. It must be followed. And if you don't follow the process, you're unlikely to be successful. But I would say of all the cases I see, the largest percentage are valid. There is an entitlement to a rent repayment order. 3 or 4 years ago, for HMO not having a licence, these settlements were averaging about 97% of the amount being claimed, and that has gone down. It's more like 75, 80%. Some people will claim it's lower, but we haven't seen that. But the most important thing to understand about a rent repayment order is both the landlord and the tenant, both their names, if there is a hearing and the determination is done by the tribunal, both their names will be searchable and the address will be searchable on Google for that offence of not having a licence or an illegal eviction, etc. Now, some people may not worry about that, and I think with the forthcoming Renters' Rights Bill and the landlord register that we're going to have in the database and the things and evidence that's going to be contained in there, I think if you are getting things wrong, the ability to keep that not disclosed or secret is going to disappear.
Yeah.
So I think what we're going to see is more and more people are going to find, like they've had a parking ticket, maybe they've had a small speeding ticket, you'll find more and more landlords and letting agents are going to have offences against them. And then we'll be looking at them as to how severe the punishment was, how severe the offence was. But rent repayment orders, there are plenty of people doing them. We, in the last 6 months or so, I'm informed by the team, we've saved landlords £750,000 worth of rent repayments. Is there any benefit of a rent repayment order to a landlord? No, not really. But if I had to find one, of course, it's negative income. You're repaying back income that you've had.
Right.
So it is negative income. So I would advise you talk to your accountant about that, because it might mean that you won't pay any tax this year, but you won't have made any money either.
Might not feel great about it either.
No.
In terms of how small or big they are, how is that determined, the size of the amount?
Currently, the legislation says they can claim up to 12 months rent, so they can't claim more than 12 months. They're not able to claim back rent for which they have arrears, and the generally accepted accounting procedures are actually put in place for that. And that was a case called 𝗵𝗲𝗽𝗽, which I was very glad to represent Mrs. Hooley. It was a very interesting case, and they went to upper tribunal, and now it's a precedent in law that the arrears must be taken before you start paying people back rent they haven't paid.
Yes.
So I'm very pleased that we did that. But it is the amounts that people are paying is up to 1 year. So the biggest one that I've seen for one property was 90,000.
Wow.
Yeah. The lady did eventually have to sell the property. She came to us after the determination, after it had gone too far, and there was very little we could do for her.
Okay.
If she'd come to us in the very early stages, I think there was a lot that could have been done. I think it could have been reduced. And I think the lawyers that worked for the tenants were quite vicious. They are ruthless. And I wouldn't get in a fight in a boxing ring with a professional boxer.
Yeah.
And I'd advise landlords and letting agents, if you've got a no-win, no-fee lawyer coming after you, don't get in that ring.
Yes. That's a great analogy. A couple of times we've had cases where we've had solicitors out the blue send us a letter, or the agency a letter, to say, they're making a claim for something or another because we hadn't served something or whatever. And we've looked and said, well, that's not the case. I remember one, this is some years ago, where there's a claim had been made. I can't remember the exact details. A solicitor had sent a letter to say they're claiming on behalf of a landlord we hadn't served something. And I just got the office to send them the document with the tenant's signature on it to say they've received it. And that was the end of it. We didn't hear from them again. But many of these agencies are quite happy to pursue these cases on a no-win, no-fee basis, because they know that they're in a good position.
Yep. This is really common. So the ones we see the most are deposit protection claims, claiming that you didn't protect the deposit.
Yes.
People try to defend that, and sometimes the amounts they're looking for are ridiculous and outside the framework of the law. So seeking advice at the beginning to find out and have somebody look at the initial letter is the first thing to do. Most of the times it can be reduced sometimes to zero. If you are guilty, then you want it to be resolved, and you don't want it to go to a hearing in the court. So the ideal thing is to get into mediation.
Yes.
Should you try and mediate yourself or negotiate yourself? No. Why? Because you are not going to get the best deal, because you're going to say things and do things which give the other side advantage, whereas somebody independent who spends their time guarding their words, thinking about it and understanding the law is going to do the best job for you. You're also going to get lots of those letters for things like disrepair. And with the Renters' Rights Bill and the Decent Home Standard, the Decent Home Standard, the private rented sector, quite frankly, is much better than social housing sector. But it doesn't stop them going out trying to get it. And the Decent Home Standard, in reality, we've already got it. It's called HHSRS. It's already enforceable under the Housing Act 2004. We're just giving it a new name, an easier way for people to go after you. So I think we're going to see a lot of spurious claims. I think knowing how to spot them and knowing whether they're right or wrong. And we had a situation just this week where the landlord has had a disrepair claim. We've been working on it for a little while, but this week they've claimed that the repair isn't done because the leak is coming through the window again. So on investigation from the roofer, he said this isn't now an issue of the leak that was coming from the roof has been repaired. What he's found is that there was an issue with the pointing on the wall.
It's a different problem.
So it's a different problem. And having spoken to two roofers, we spoke to one of the a guy who's a roofer in another one of the landlord's buildings. He happens to be one of his tenants. And it was interesting. He said a brick can retain up to a pint of water.
Wow.
So what was essentially happening was water had got through. It was dwelling inside in the brickwork or the blockwork. And when the torrential rain came on the weekend, it essentially overflowed the dwelling brick. And that was what was causing it. So they managed to get on with it and get it fixed. And I think that will be repaired. But that's not without a few very nasty emails of allegations from the landlord and the solicitor for the landlord, which were really unfounded because they don't have the technical understanding.
Yes.
So it's very important. If you're going to fight fire, fight it with fire. And if you're going to fight, do it properly. But if you really want to do it, you need to fight with the fire first and then the water that's going to put it out.
Yes.
And sometimes you're putting water on it. It looks like water, but you're actually putting more fuel on. So make sure you're using the right thing. And like any fireman would tell you, sometimes you need foam, not water. So it's about knowing the right thing, and seeking advice at the beginning is probably going to be cheaper because it can be dealt with at the early stage. If you leave it too long, try and fight it yourself, you're basically asking somebody to jump in the ring and fight for you after you're losing.
Yeah.
And, you never see that on the TV.
No. So when we talk about rent repayment orders or penalties that are levied, you'll have a tenant, you've got a letting agent, and you've got a landlord. In some cases, you might have a renter somewhere in the middle somewhere as well. Who is ultimately responsible for these? Because there's changes happened recently in terms of who takes responsibility.
Right. So rent repayment orders, let's deal with those first of all. As the law stands today, and because it went all the way to the Supreme Court, only the immediate landlord can be liable for a rent repayment order.
That's the one that collects the rent.
That's the one who collects the rent, the name on top of the tenancy agreement.
Yes.
So that's the one who will be held liable. Now, could somebody else be liable for a rent repayment order under the current legislation? Not as it stands. But there has been a case recently where, through the connivance of the husband and wife team and a company in between the ownership and the tenancy, it was found that essentially the owner was an undisclosed recipient, an undisclosed principal in the contract, should I say. And what that means is that they were using a company to hide the fact who was actually ultimately receiving the rent. In that particular case, it was a husband and wife. And in that particular case, they were claiming to be estranged, whereas social media claimed something different. But the chances of something like that happening again before the next change in the law is very unlikely. I actually defended a case 2 weeks ago where I was able to prove that the landlord had no relationship with the tenants, and quite frankly, there were a number of people in between. So on rent repayment orders, Hussain 𝗵𝗲𝗽 and the Supreme Court ruling stands unless there is proven undisclosed principal in the contract who's receiving the rent and being shielded by not being disclosed. So that sounds very complicated, so hence get clarification from somebody who's doing this on a daily basis. The other side is the fines. Now that's very different. With fines, it comes down to who is responsible. And a lot of this was tested essentially in a rent repayment order case when they came to the decision at the Supreme Court that it was only the immediate landlord. And in that case, they said that the local housing authority had the ability to fine other people or to enforce against other people in the process who weren't the immediate landlord. So that could be the letting agent, that could be a rent-to-renter, that could be a rent collector, that could be a superior landlord. It could even, in some cases, be a leaseholder or a freeholder. And it all depends on who is responsible under one section of the Housing Act 2004, and that's Section 263. And interesting, one of the first cases I ever dealt with was on Section 263 and deciding whether there was a case and whether there was who was responsible. Because in that case, it was a rent-to-rent company that was being enforced against. There was a global international agency who'd rented the property to them who was also involved. There was a landlord who lived abroad who was involved, who was the leaseholder, and then there was a freeholder.
Wow.
Now, for the council, This is like having a slot machine in front of you that's just going to pay out. You press the button and you're going to get the jackpot every time, because if they can prove each and every one of them is responsible, they will get fines for all of them. So we have seen situations where essentially a rent-to-rent operator has not applied for a license, has also breached HMO management regulations because they've sublet the property and not made it compliant. So the rent-to-rent operator has had a fine. The agent that let it to them that's receiving the rent has had a fine. The owner of the property has had a fine.
Wow.
And they tried to get the one above them. So what should have been, I think the fine in that case was 27,000. Yeah, they got 3 times 27. Yeah, so think about £81,000, but that's per offence. So if you've breached HMO management regulation 4, which is safety, and you've breached regulations 7 and 8, which are the 3 most common, which are design, maintenance and care of the common parts and the individual letting rooms, and you've got 3 of those in your portfolio landlord, and I can quote it because their policy would be, say Camden's policy would say there were 3 there and they should be £20,000 each. That's £60,000 times 3. You're beginning to work out it doesn't have to be about the money. It's about the culpability. And quite often I get well, that's not fair. It shouldn't be. Well, if it's not fair, if you're old enough for me to remember the Great Train Robbery, and Ronnie Biggs and Buster Edwards and all of those, does just one guy in the gang get done, or all of them? And you've got to see it from that point of view. So if you're in the chain, you're likely to get done because the council, 1, can do it, and 2, they are able to do it because of what the law says. But what's even more interesting is that if any of those organisations is a limited company, or those people are getting the fine, and that happens to have one director who's actively involved on a daily basis, then they can also use Section 251 and say, because you're the director and then controlling, and you're controlling the company and making decisions, you are also guilty.
Wow.
And get the fine as well. And we see
another entity added in.
Another legal person. So we see this quite often, and it can be really, really frustrating. So I can give you an example of a landlord who that happened. He got some fines. I think they came to 58,000 because they did the company, the director, and the agency that happened to also he owned. So there were three of them. But then when it came for the license on the same property that was up for renewal, and this time around the council wanted to apply some standards. And those standards were going to take some rooms out of operation.
Right.
So they would be taken out of the license. So he paid us to advise him on how to deal with the license inspection. And based upon the license inspection advice we gave him, the 60,000 he was now going to lose on top of the 58,000 he was going to pay in fines. And we were able to at least reinstate the 60,000 by advising him how to advise the council and get the council to agree with their discretion. So it's always good to take advice.
Yes.
Really good to take advice, because you'll see it in a different way to anybody else. The council, they are the police of housing. They're going to do what they're going to do, regardless of whether you like it or not. I wouldn't, if I was accused of a crime, think about going into the police station and fighting it myself. I'd probably get a solicitor.
Yeah.
And if I was going to get a solicitor, I probably wouldn't choose somebody on the high street. Not that solicitors on the high street aren't good. Many of them are very good. I'd want somebody who's specialist in what I do.
Yes.
So if I was getting done for something to say with speeding, which is a criminal offence, by the way, I'd get a speeding specialist.
Yeah.
If it was something for parking, I'd get a parking specialist. If it was something like an affray, I'd get an affray specialist. Anything else I wouldn't probably think I'd be guilty of. But it's, imagine fare evasion. We know that some of the companies got that wrong. You got done for fare evasion when you didn't think you had. You'd go and find a solicitor who's experienced in fare evasion, not somebody who's doing a bit of family law next week and a little bit of conveyancing the week after. You want somebody who's specialist in it. I think that's the bit that we've got to get right in property. And I think for somebody like yourself who's an educator, I think from this year onwards, every educator is going to need to have somebody working with them to advise on the legal, the legislation, how the regulations work. Because building a business is hard enough, But like any big business, they tend to have a legal department.
Yes.
I think any business now that's going to be taking people forward, training and moving them forward in education, they're going to want to work with people who are going to be able to step in and tell them the facts and the law as it is and how to avoid getting into trouble. So these fines and these rent repayment orders don't come along. Are they possible that it's going to happen to you inadvertently? Well, I know I've broken the speed limit a couple of times.
Yeah, and these are landlords are sitting ducks in a way. They're easy targets, and even a most well-run business may have issues and problems that might have got missed. So the conversation leads me on to thinking about rent to rent as a model and a strategy, very commonly used, talked about. I think it can be interpreted or misinterpreted in many ways in terms of the structure and how it's set up. So give us your thoughts on some of the do's and don'ts in how a rent should or shouldn't be set up and the risks around that as well.
That's very interesting. You should bring that subject up. We get a lot of calls from a lot of people who are rent-to-rent operators when they're in trouble. And the questions we ask is, where did you learn? And quite often they didn't learn from anybody, but they copied somebody else.
Yes.
They looked at something on YouTube. They didn't have all the facts and information. So
Googled a contract.
Absolutely. Now, I'll come on to that in a moment. So rent to rent, most people are not doing what they should do, which is learning how to do it properly. They're like getting in a car, and you see this quite often with high performance cars given to youngsters who don't never driven one before. 2 minutes later, it's crashed. Well, lots of people are going into rent to rent without understanding the legislation, the health and safety. They don't understand the licensing. They don't understand room sizes, all of those things. So first of all, learn what the legislation is before you go chasing the money. Secondly, be frank and open with the people that you're dealing with. If you're going to rent from somebody, tell them what you're going to do. Don't take the property and then change it and tell them afterwards, or the first they know that you've sublet is when they get the letter from the council saying, we've had an application for HMO license. So rent to rent is a very successful business model. Very successful. If you look at probably the best rent to rent model outside property that we see is banking. You rent your money to the bank and they rent it to other people. Yeah. You rent it to the bank, they give you 0.5% maybe. Yeah. And they rent it out to somebody else and they pay 30% on their credit card. Yeah. It's good business.
Yes.
Now, banking has regulations. Banking has ways that you have to do things. So you have to think about, you're going to do it properly. When you do it and you put the contract in place, is it the right contract? I see so many people using common law tenancies or company letting agreements, which aren't essentially the right agreement. Some people use leases, which again are badly drawn up and don't have the right information. Everything needs to be understood by all the parties and the superior parties. Often these contracts say, oh, I'll comply with the head lease. Have you looked at the head lease that you're trying to comply with? This is basic business stuff. And with no criticism of anybody who's teaching it, I think the most important thing is teach it properly, learn it properly, and have somebody guiding you through it. If you're going to enter into a contract, make sure it legally stands up. I see every single week a contract that doesn't stand up, or a contract that it's not really a tenancy, it's not really a lease, it's just an agreement
Put together. Yeah.
And then what we also see is the assured short tenancy, which the tenant goes in, is the most powerful contract in the chain. And the tenant has more rights than the landlord, and more rights to tenure. So going forward with the Renters' Rights Bill and with assured tenancies, and periodic assured tenancies as they're going to be called, we are going to see that the owner of the property or the superior landlord, they're not going to be able to seek possession as easily as they are currently by saying, let me give you notice, you serve a Section 21, no fault. And it's not properly covered yet under what the grounds for Section 8, because Section 8 is about moving back into the property and it's being catered for, about selling the property. And if you use those grounds, well, there's a potential 16-month period if you fail to move in or fail to sell, where you won't be able to market the property. So you're going to have an empty property with costs that's got no income. Now, I hate to say it, an empty property with no income is better than an occupied property with no income.
Yes.
But you've got Section 8 for that as well, for tenants who don't pay. So there are problems that are going to be afoot. So if the rent-to-renter wants to get out of the business or becomes insolvent, where does that leave the superior landlord? Well, in the insolvency of the business, the law will pass those tenants to the superior landlord, because there's no immediate landlord. And then what will happen? And what if that superior landlord is unsure or uncertain, or does no knowledge to the fact that they've gone insolvent and he's now got tenants, and he's not receiving money, and he's not compliant, and then the local authority becomes involved? It all becomes a little bit messy.
Yeah, very quickly, yeah.
Rent to rent of the future will have to be done in a professional way with full understanding, and the superior landlord, i.e. the person granting the rent to rent agreement to the rent to renter, is going to need to understand their options and the implications of maybe not being able to get out of it. And I always remember listening to a podcast from somebody who talked about his parents being in Scotland, having a property that it had a lifetime tenancy. And when they literally got it back after 60 or 70 years, of course, it wasn't what it was expected to be, and there was nothing they could do with it except sell it and get rid of it as quickly as possible. Well, is that what people are investing for? So investment strategies, the teaching of investment strategies, are going to have to take into account who are you leasing it to, what are the circumstances. And I think we see a lot of people talking about rent to rent and giving it on government-backed social contracts, etc. Those also need to be examined as to what is the real situation, and whether those people who are living there have tenancy rights that are undisclosed or misunderstood. And if you're going to go down the lease it to a social provider, what's your experience of dealing with them? Do you fully understand it? And if you're going through an intermediary, you don't want to be like the chap that we are doing some work for down in the Berkshire. He actually lives abroad. Before he involved the agent that we advised him to work with, he was renting it to a social housing provider, he thought. They're renting it to another organisation who basically gives it to Home Office asylum seekers, etc.
Right.
And the properties come back, when they've served notice, the properties come back 4 months late and £60,000 worth of dilapidations.
Wow.
And then to find out that it looks like the director of the company may be in all sorts of other troubles as well. So they're not holding out a lot of hope, and 3 years of profit that they've got has just been wiped down in dilapidation. So rent to rent as a model, as an investor who wants to rent your property to a rent to rent operator, I think you have to be very cautious. It's not how it was. Why did it all change? I think rent to rent became very popular after the General Permitted Development Order of 2010, which came in October 2010, when you could change a property from a residential home to a HMO C4 use without the requirement to change a house from a residential C3 use to a HMO C4 use to 3 to 6 persons, and you could do that without the need for planning permission.
Yes.
So people were doing this. It was in 2018 when they removed the requirement for mandatory licensing to have 3 floors, 5 occupants and 2 households. When that changed, it all changed again and got even tighter. And it was at that point rent to rent became less profitable than it was before. And that's when it started to change. And I think over the last 6 to 8 years, we've actually seen less and less profit in rent to rent being done legally. And because of the requirements that use 2 households and 5 occupants for mandatory licensing and the introduction of additional licensing, the extra costs that people were not expending before are taking the profit away.
Yes.
And you're seeing more and more illegal ones because they're going, well, I'll get it done after I've applied for the license. But what's happening? Enforcement's happening before they get it done.
Yes.
And more than just the rent to rent, the landlord is getting done as well, the owner. So I don't think it's a model that's going to continue unless people are going to pay more than market rent for them. Rents are going up. There is more and more demand. But the idea of renting a property and arbitraging rents, I don't think it's going to continue the way
it's evolved significantly.
It has massively changed. And if you're creditworthy to be able to do that, then it's likely if you've got a job that's giving you an income or a business that's giving you an income, you would be mortgage worthy. And if you're doing it properly, then it should work as well. And if the numbers don't add up, or you're looking to work on a commercial valuation and the numbers don't work, there's a reason they don't work. You've got to work at it. it is becoming harder, it is becoming tighter. But if you look at any industry where people tend to make large amounts of money, over time, legislation will reduce the profitability because more regulation, more safety, etc. You've only got to look at new technology. Lots of money at the beginning. Over time, as it becomes more prevalent, less and less money is made from it. There's no money in making PCs, in selling PCs anymore. There's probably isn't money in making phones. The money is on the service contract, and there wasn't money in cars.
Yes.
The same is happening in property, and I think we're going to change into a service business. Landlords are going to have to provide more, and they're going to have to do that at a premium.
When we look at a serviced accommodation model where there isn't a tenancy issued to the occupier, how are some of the things we're talking about important in that situation, things to consider?
Right. So rent serviced accommodation is very, very popular. And there are lots of people teach it and lots of people do it. But is it legal? Well, that depends. Having defended many planning enforcement notices for clients where they've done serviced accommodation, sometimes it's okay, sometimes it's not. We see a lot of people saying, I'm going to rent a property to contractors. Those contractors arrive, they've got 5 or 6 people staying in a 3-bed house. All seems pretty okay until the neighbour says, well, there's 6 vans down the road or 6 cars down the road every night. They're no real problem, but there's an awful lot of people going in and out and we can't get a parking space. That's how they tend to get reported. Now, has the property changed from being a residential use? And are they a cohesive group? Well, if there's 6 people working with the same company, working on the same contract, or there's 6 people working on the same contract, they may work, say, on HS2 together, but they've got somewhere else to go back to. So at the weekend, they can go back to Darlington.
It's not their primary residence.
Yeah, it's not their primary residence. They're only temporary. Now, has the property changed from residential use C3? Probably not. And most of these people will book a month at a time. So most councils will go, it's not causing a disturbance, it's not an issue, and it hasn't changed from residential use, and it could go back to being a family home at any time, or it is a family home, it's just being used for this short period by people constantly. Some councils will say, no, you've changed it to short-term letting, and we need to have that either under sui generis, or we want to put that under C1 class use.
Like a hotel.
So again, every council is interpreting it differently. Yes. Whether you want to go through the planning enforcement route, that's up to you. But we've helped people who they've got to a point and I've said, the way you're doing it, it really does seem like you're running a hotel or you're running a holiday let, and that's a change of use.
Yes.
And you also would have a different status with the 𝗵𝗵𝗹𝗽. Many people don't realise this. There are different statuses about how properties are let as to whether you're doing furnished holiday lets as well. So it gets complicated. So if you're going to do rent to serviced accommodation, in the city of Westminster, the borough in central London, they've got thousands upon thousands of properties that are in breach of the 90-day rule. And they've got a workforce now for enforcement looking at all of those properties to stop that happening.
Yeah.
Because people are arriving. If you're using it like a hotel, essentially you're in sticky mud and it's very dangerous waters. But most people, if you're renting out to, say, 6 contractors, we've had a case recently where the council's arrived. They've not only arrived with the HMO officer, they've arrived with border force.
Oh, wow.
So they've come and they've inspected. And on the border force or the Home Office documentation, their right of entry was under the Housing Act warrant.
Wow.
So, and then on top of that, when the landlord was looking at the situation, he also had the fire brigade come and wanted to inspect the property as well, because people don't realise if you're doing serviced accommodation or short-term lets, you're running a business, you're required under the Regulatory Reform Fire Safety Order of 2005. It's not a new regulation, it's an old regulation. You are required to have a fire risk assessment for sleeping accommodation.
Many people forget that.
They have no idea they've got to. Oh, I made it like my house at home. No, you've got to have those fire doors. You've got to have those interlinked smoke alarms. Quite frankly, you need the alarm connecting to your phone and telling you there's any problem, because you need to save people's lives.
Yes.
And lots of people are moving into these places for short term, etc. I've worked with a number of cases where the council's done enforcement, and if they've got somewhere else to go back to, then it's not their home. Then a tenancy hasn't been created. But if it's a short-term let, are you creating a hotel? That remains to be seen. Every case has to be looked at. We had a case in the East Midlands 6 years ago, maybe, and the council said it's advertised on a minimum 1 night stay. It's up to 9 people in a 3-bedroom house. It's causing all sorts of havoc, etc. Through negotiation, and it took a lot to deal with, we eventually got them to agree that they could have 6 people. They could book once a week, up to at a week at a time. The reason being is this house just happened to serve the local theatre. Right. And they wanted it for theatres. Okay. They wanted the theatre people to say, because they were a cohesive group coming and going at the same time. Mm-hmm. They weren't parties every other night. They were the actors and the musicians, and they were limited to 6. They also had to take a car park spaces at a car park at the end of the road for those people to stay in. Yes. So it was agreed that they weren't going to enforce, but they did want to see every booking that had happened, how much money they'd taken, etc. So the council was fully aware of how much money was being made, and it was quite an effort to get them to agree. But they didn't stop it because they just didn't feel it was necessary. They weren't desperate for housing in that East Midlands town. Yeah. But some councils, they want to stop this because they're working with their empty homes departments, because they want those properties to put the homeless people
as regular homes. Yes.
Yeah. If you're going to treat them as hotels, well, why can't the council treat them as hotels? And I think there may be something, and it's only a suspicion, but when you look at the Section 8 part of the Renters' Rights Bill, and the fact that you won't be able to, if you want to move back in or you want to sell it, that you won't be able to let it for 12 months, which could be 16 months. And there's an empty property of which the council can get double council tax in some areas and more. What do you think the council might be suggesting to you? They might be suggesting to you, we might be able to get you out of your problem, and because there's an empty house there that's going to be empty for the next 12 months, maybe we could use it for short-term emergency accommodation. It's just, if you're into conspiracy theories, maybe you'll be with me on that one. Yeah. Did COVID really happen? We've all got our theories. Yeah. It's just an idea. It might be something there that has somebody thought that through? Is there a possibility? Does every house that we want to sell, do we actually want to turn it into emergency accommodation? But what we are seeing a lot of is councils have got a big problem and they need to get their hotel bills down. They are going to be looking for operators who can turn properties into suitable accommodation for emergency accommodation, for those office to commercial residential, if it meets all the requirements. And again, we see a lot of planning enforcement and housing standards enforcement against offices to residential. Yeah. We see issues with that and enforcement because they're saying they're too small, or the tenants moan, or there are issues. If you can make good quality stuff and make good quality buildings that are habitable for the different types of people, then you're probably going to have a great tenant, and the council's going to use it for emergency accommodation to get their housing lists down. But remember, many of them don't want to turn these offices into residential. So make sure you understand what the local plan is. You understand that you don't want enforcement, because you don't want to do something great and then find yourself spending 2 or 3 years defending an enforcement action while the council's people are sitting in it. Yeah. Remember, the homeless prevention people don't work with the housing standards people, who don't work with the planning people, who don't work with the licensing people. They're all siloed.
They're very disjointed approach. And you touched on enforcement there. Most of what we've been talking about, it's tenancies. And when you have, say, a planning enforcement notice sent to you, what's the best way to approach that?
So when you get a planning enforcement notice, it's unlikely to be the first communication. A council will take, the first step is generally, if they get a report or they believe something isn't right, they'll send what's called a planning contravention notice. Now, that is a notice which generally has a bunch of questions they want you to answer and to sign, back to the signing part. Now, if you sign it, of course, that's more or less a witness statement for them. Yeah. Many people fill those in and give them everything they want, and then that's followed up either by a planning enforcement notice, or they don't do anything more because they don't believe there's any enforcement required. There is a fine if you don't respond within the 21 days. So you're advised to do that. But the bit that most people miss is you can fill that in and respond, or you can make a representation. Now, when most people make a representation, they write what they think is important rather than addressing the problem and the legislation that they believe is being alleged.
Right.
So I always advise you to get professional advice because it's faster and quicker to get somebody who does this all the time to do it. And we generally make representations. When we make a representation, we represent the situation and solve it generally. So there is no planning enforcement. So you talked about serviced accommodation. So a lot of people in London have got ex-local authority flats that they've rented to somebody, or they've renting out on their own accord. They're renting them out for serviced accommodation. You will get a planning contravention notice. Most people will fill it in and give them all the information they need. But if you're going to stop doing it, as we had in one particular case, it was a rent to SA operator. She came to us, we looked at it, then we looked at the lease of the building that the landlord had with her. We looked at the lease for the building for the local authority and with the landlord. And she had a 3-year agreement with the landlord. Right. So he's the leaseholder. But his lease said he was not allowed to grant any subleases or underlettings to anybody for more than 12 months.
Okay.
So because her contract now was an invalid contract because it was for 3 years, we were able to represent back to her, for her, that she was not going to continue. The property was going to be taken out of use within the next number of bookings. So we never provided all her information about the money she received. We didn't give them any evidence which was beyond reasonable doubt. We just said that the current use was going to cease with effect from such and such a date because notice had been given to the leaseholder and because the leaseholder had realised that he couldn't let it in the way that he should do.
Yes.
No specific details, no anything, vaguely specific and specifically vague. And they wrote back and said, we're taking no further action.
Yeah.
The owner said, oh, thank God. He then let it out as he was supposed to.
Yeah.
The problem went away. But it's knowing what to say and how to say it and knowing who you should contact to do it rather than filling in and answering. We're very, very trained from the days when we're very young to fill in form, name, address, date of birth. We fill them in and we sign things.
Yes.
You go to the doctor, you go to the dentist. We get all this information. So we do the same with the council. And then we realise that we're self-incriminating. The law says you don't have to self-incriminate. As the Americans say, I'm going to take the fifth, however they say it. And you don't want to incriminate yourself, but at the same time, you don't want to mislead.
Yes.
But if you've been caught doing something and you want to stop it.
Yes.
Yeah. If you haven't got a license and you should have a license, get one.
Yes.
Yeah. Yes, there may be some consequences of it, but so many councils have got such a backlog with licensing that they don't have the time to get them done within the 6 months of which they have to enforce. So if they don't process your license for 7 months, then they can't enforce a fine against you.
Yes.
So there's so many things that people don't know, and just a quick phone call, find out what you need to find out, and then get the answer. And if you need more help, get more help. If you need to be consulted with, get that. If you need a representation, get that done. But what I would never try to do, my son is, he's taking up rowing at school and he likes it and it's a lot of fun. But I would never try and go out and be a rower like he is. If I want to learn about rowing, I'm going to ask my son. If I want to get trained for rowing, I'll ask my son.
Yes.
I'm not going to go off and try and do it myself. And fortunately, because landlords and letting agents want to make profit, because we get trained to do so many things and we think we know how, we think we're going to deal with it, or we can ask a friend who's had similar happen. Never have I seen two pieces of enforcement look the same. Not
getting the right piece of advice is essential.
Absolutely.
And we, before we start kind of wrapping up, I want to talk about the renters reform.
Yes.
And what's your view on what looks like will happen and how do you see things panning out and the impact for landlords? It's quite a broad, big question.
Okay. In simplicity, the Renters' Rights Bill, which will become the Renters' Rights Act 2025, it's going to mean more powers for the local authorities to enforce and get fines for people who are guilty. Yeah. It means landlords are going to have to do more, sometimes for the same.
Yes.
So like many businesses, you're going to be forced to deliver more for the same price. For tenants, it's going to increase their rights and give them more rights to and an ability to go after landlords and letting agents. And because of that, you're going to see letting agents and landlords feeling that tenants and local authorities are against them. It's a bit like deciding the speed cop with the camera or the radar is against you. What we have to do is we have to tighten up.
Yes.
Like the 𝗵𝗵𝗹𝗽 tightened up the construction industry, stopped cash payments, stopped the construction workers going to the pubs like they did on a Friday night to get their money from the landlord who the construction firm had delivered the money to. Those types of things are going to stop. So landlords taking cash payments, they want to stop that. So it's recorded. They want to see people doing things the same way we've seen the insurance industry, the driving, we've seen the licensing, the food industry, the supermarket industry, consumer rights have all tightened up. Construction has tightened up. It's just our turn. We just need to decide we're either going to conform and get it right and reduce the risks, or we're not going to do it. And if we're not going to do it, there's two options. Pay the fines until you realise, parking on this double yellow line isn't working anymore. Yeah. Or you're going to be forced out of the business because they're going to shut you down.
Yeah.
So the typical process for one particular council in the Northwest is first property, first offence, fine. Second property, third property, fourth property, fifth property, prosecute. More properties, fines. Why? Why do they do the prosecution? The prosecution is really simple. Once they have a prosecution, the application for a banning order is relatively straightforward.
Okay.
And there's quite a well-known case of a banning order, and the person has come to our firm a number of times for advice, and we've never represented them because we couldn't. I don't think we could in the circumstances, but they come to us for advice, and we give them advice based on their situation. The first time, I think they were irrational about what was happening. After they got the banning order, they came to us and we gave them some advice on the things they were doing. They were talking to people who were advising them, and having looked at the determinations and the cases, I can say that they were badly advised. Even though they were very guilty, the advice they were being given and the case, how it was being fought, was not becoming from a place of contrition. It was becoming from a case of righteousness of they're wrong, I'm right. It was wrong. It was wrong. They came back again because, of course, they were trying to enforce even further for a breach of the banning order, and we've gone through that process with them as well. And they kept wanting us to represent. I said, "We can tell you the facts. I can tell you the truth, but I'm not prepared to condone the conduct."
Yes.
We are here to defend people who want to get better. We're not forgiving sinners, if that's the thing that some people are probably thinking they're hearing. What we're doing is making you better. If you've had a drink driving offence, you have an option to have your sentence reduced by going through a rehabilitation. If you break the speed limit and it's your first offence, you generally get to go on a speed awareness course. These are proven time and time again to be good and help people. And as one of my sister who went on a speed awareness course, she says it very clearly, and I think it's right for landlords to hear this and for letting agents. Number one, if you are driving along the high street at 29 miles an hour and somebody falls on the road in front of you and you hurt them and kill them, the police will defend your position that you didn't do it on purpose. Even if you're driving at 30, they will defend your position. But at 31 miles an hour, you have committed manslaughter and killed that person through your breaking the law. That's the difference. Now, the same in the 20 mile an hour zone. 24 miles an hour is the most common speed. Yeah. But you're still breaking the law. Yes. And that's how we have to see this with landlord offences. There's strict liability like speeding. You don't have to be aware that you're committing the offence for you to have committed it. So If you don't have a license and you didn't realize, you're still guilty. If something is broken and you don't know about it, as I said before, if you've got repair records, etc., then there will be some leniency, but the offence is still being committed. And if your tenants sublet and let more people in and create HMO that you don't know about, and you're breach of HMO management regulations or licensing, that's still guilty.
Yes.
And I know that's tough to deal with, but that's how the law is. And it's not only been tested in the tribunal, it's been tested in the upper tribunal and the High Court and a judicial review. So very, very tough and a hard pill to swallow, but we have to accept it most of the time. And it's difficult because it feels like the landlord and the letting agent is playing to everything.
Yes.
But if you manage knowing this and you've got the systems and processes, I found that most things can be solved. And as much as it may seem that I don't like councils and I want to slay them for everything, most of them are doing a good job for the right reasons, for the right people. And if you get your first piece of enforcement, getting 3, 4, 5 or 6 is stupidity.
Yeah, you need to learn the first one.
If they happen rapidly one after the other, quite frankly, if I had the council knock on my door and I found out I had a property in problem, I think I'd be a little bit like a Hollywood filmmaker, and I would go and get as many people as I could, as many people as possible, to get in every house possible. I'd overpay every carpenter, every fire risk assessor, and even if it was meant I had to mortgage the house to get it all fixed in the next 5 days and get every house compliant, I'd flood all my properties so they couldn't go to the next one and go, got him.
Yes.
Why? Because it makes common sense. Yeah. I know it sounds like something off the movies, but think about it. If you know you're going to get done on one, all they need to do is look up your name or your company and go, how many other properties have we got?
They can find it very easily these days.
Yeah.
The data is so easily accessible.
The most common way for councils to find out issues is from the council tax list. They search all of these things. And one of the things that people don't realise is once they're investigating you, they will look at the property and they will do credit searches for the property of all the people. And they are allowed to do that because they are investigating what they believe to be a crime. It's not breach of data protection. It's not breach of any of those things. And quite often I say, they can't do that because of data protection. I can't do that. I had a guy tell me yesterday, I didn't apply for a license because when they did the consultation, I told them in writing I could see no justification for it. Right. Okay. Yeah. The £17,000 rent repayment order has done a little bit to shaping his mind and thinking. Yeah. Luckily, he's outside the 6 months for the council to do anything. But these are the things that we hear on a daily basis. I would say if there's one thing we should do, and I will change that word to must, the one thing we must do is learn what we need to know about running our properties. Because when people say to me, it shouldn't be like that, or it's unfair, my heart dies for them because it breaks. Because the whole thing is, those are nice phrases, but the law doesn't care. It doesn't care whether you're innocent or guilty. It cares. This is the law. Have you complied or not? And if you complied, you're innocent. If you're guilty because you haven't, the law is going to deal with that. Can you limit those fines? I would say if you had a different company for every single property and you thought, yeah, that's how I'm going to get around this. Remember I mentioned section 251?
Yes.
They'll look for you as a director and go, we can connect all of those. He's a portfolio landlord who's got 30 or 40 properties, the highest fines. And those fines, I hate to say, yesterday seeing two £19,500 fines come in for a letting agent who already has had 4 cases where he's had fines already, 1 prosecution, all because he wasn't close enough to his business, is breaking him. But he's standing tall, taking responsibility and changing his business. And I'm glad to say he's taken the advice. We're going to go and help him. We're going to get it sorted, and that will be part of his mitigations.
I think the operational procedural part of the business is really important that we don't really talk about much in this industry. So I'm really pleased that we had this conversation here today as well. And the education is important in this sector. And if somebody is facing a challenge, they really need to reach out and get that professional advice, as you suggested. And if somebody wants to reach out to you and connect with you, what's the best way for them to do that?
The simplest way is if you use a phone for what it was designed for, is to dial the number.
Yeah.
And the number is very, very simple. It's 0208 088 3494. That's 0208 088 3494.
And we'll put that in the description as well. We'll put it on the screen
Of course.
as well. That's the easiest way for someone to connect with you.
Absolutely. And of course, if you look for my pretty face on social media, generally, my name's Dez Taylor, as you said. You'll find me on Facebook and LinkedIn. And of course, if you want to message through that, somebody in the team will also pick that up. I'll be frank with you, I spend a lot of time in front of clients. So getting hold of me directly, if I don't respond back to you, I ask you to call the office. It's not that I want to be rude. It's been, I'm trying to respond back. And I feel that people, when they come to us, they're in distress.
Yeah.
They are anxious. They don't know what to do. And because they can't get hold of somebody instantly, they do something. My advice is, don't just do something. Send a message twice. Because sometimes we miss things, we do things.
Yes.
So don't ring twice. And of course, if you ring on the weekend, somebody's not going to pick it up till Monday. But the key thing here is when something happens and it's not what we expected, anxiety kicks in, thoughts go crazy. What shall I do? I should do this, do that.
Yes.
We ask a bunch of people who don't know the answers. Great, take that on board and then get the advice. But the most important thing is, imagine you're in a trauma situation. The doctor, the ambulance person, the medic ask you specific questions to get specific information.
Yes.
Yeah. Most people want to just tell you everything. And the most important thing when something goes wrong is to know what are the key things. How did it happen? What was the trigger? Who's involved? How many people, etc. And what happened immediately before. Most people aren't thinking about that. We think into the future about the consequences of something that hasn't happened based upon the words that we see.
Yes.
So always, if you receive that letter from the tenant, that letter from the solicitor, that letter from the council, that letter from a third-party agency saying you've done something wrong, it doesn't have to be true just because they wrote it.
Yes.
It only becomes true if you make it or if you tell them it is, until such time as it's been investigated and the action is decided to be taken. Nothing is that urgent unless it's a fire or something like a flood happening to a building that you need instant. So sometimes it's just better just take a walk, take a drink of water, and then go on the phone calmly and talk to somebody. But please, no matter what happens to you, that letter you receive, do not give it meaning it doesn't have. Seek advice.
Yes. That's a great note to end on, Des. I'm really pleased to have you on, sharing some of your knowledge and expertise, and such an approachable person as well. So thank you again once more.
Thank you.
Thank you.